Morning.
Good morning, everyone. Here we go again. It is Monday, June 8th. This is the 174th time that we've gotten to do this, and we'll see if we got anything actually happening. Joining us, as always, are my two wonderful co-hosts, Hannah Hill from the National Association for Gun Rights. Good morning, Hannah.
Good morning, Bill. How are you?
I'm well, thank you very much. And Kostas Moros from the Second Amendment Foundation. Good morning, Kostas.
We'll see, as I like to say.
Kostas has just been just spicy the last couple of mornings.
I'm getting tired. It's late in the term, man.
That's right. That's right. Let me remind all you guys that both of my co-hosts are here. Compliments of their fine organizations. Kostas with the Second Amendment Foundation, Hannah with the National Association for Gun Rights. There are links in the description box for you below to show both of their very worthwhile organizations some love. So please do so. Okay. As I mentioned, here we go again. It's and by the way, you know how they have like Puxatawny Phil in that movie? I think we've got to come up with our own DC Daryl. That's our little groundhog there. And when every time he comes out and sees his shadow, it's another week before we conference again. Our usual suspects, of course, are these 5 cases right here. There's a few other cases that we're going to be checking out today. One of the cases that comes on for conference, a case that I thought was very important, but I'm suspecting that the Supreme Court doesn't see it that way, is the National Shooting Sports Foundation case v. James. That's on for conference for the first time today. Both the state of New York and the city of New York were able to waive their reply briefs, and now we're sitting on a first conference. So according to Kostas's theory, which seems to work very well, I've noticed, that's probably not a good sign. So Kostas, any words of wisdom before we get into the orders list today?
No, just refer back to the last 15 episodes. I don't know.
but Kostas is definitely getting a little more antagonistic as each week goes along. So, Hannah, did you have a great weekend?
I did have a great weekend.
All right.
Tried to forget all of this and recharge.
And you were breathing into a paper bag this morning, right?
I was.
Well, let's see if we got ourselves. The orders list comes out in about a minute or two. Let me go over a couple of other things real quick, just so you guys can understand. Guys, we are down to 3 conferences. Now, depending on what happens today, we may not even get to do another WGL. You never know when it's going to be our last one. But we got 3 conferences. I think they're all set for Thursdays. We'll be back on Mondays. So that is, someone asked me, what do you think the chances of something happening today was? And I was like, well, there's 4 conferences left, so about 25%. So next week, if nothing happens, we'll be at about a 33% chance of something happening. So, hey, at some point, it's going to happen.
Well, there is a chance, there is a small chance that if they were to hold the cases over the summer, nothing would happen for the whole time.
Yeah. Kostas, let me ask you, you bring up a good point. Do you think if cases were to be held over the summer, which would be unique, however, not completely unheard of,
right,
does that really give us an indication one way or the other?
That means they're waiting on. That means they're waiting on the Third Circuit. That they're buying. That's somebody making a deal and buying time. Okay, we got it. Let's see what happened.
All right, we got the orders list. The orders list is out. Hannah and Kostas are going to do some quick word searches. Hannah always starts with her case. Kostas always starts with his case, and then works their way back.
My old former case
for either of those.
Oh God, are you serious? Are we doing
another dead week?
Yep.
Nothing looks like
okay. So
which one am I missing? I did Viramontes, Duncan, Grant,
Gator.
That's the one.
I mean, if Duncan got shot, isn't getting any action.
Yeah, so it looks like nothing again.
Oh well, isn't that wonderful?
At this point, let me put it this way. I've said it before, but if we're getting another denial and dissent, that's still probably the lead contender, but I really want an explanation on why it took this long. Like, why would it take this long to do that? You know, it's because we're way past the normal timeline. We're past Snope.
Oh yeah, we've gone well past
Snope. Was at 13 or 14. Now we're at 19, I think. Yeah. So
I have the stat right here. Going into today, this is it. Dunk 19, Gators and Viramontes 18, NAGR's case is at 14. Grant, the rookie in the league, there is at 13. So add one to each one of those. So that means Duncan's coming up on it. Duncan's going to get to its 20th conference now. 20 conferences. I was going back just to give you guys an idea, and I appreciate the foot soldiers that you've been for us over here. Kostas made his first appearance on WGL AM at the end of February. Hannah made her first appearance at the very beginning of March. You guys have been back every week since. I really do appreciate it because you get kind of lonely doing all big nothing burger by yourself all the time. So, hey, can one of you guys check a couple of other cases
I'm
here?
not seeing it. I was checking for that. Unless there's some combination of the name that I'm not finding. I don't think it's on there.
Okay. So this is a case that I'm very interested in. I don't know if the Supreme Court is as interested in it. This is NSSF v. James. Some of you may be aware of these laws that they write in states to try to be a workaround from the PLCAA, even though the PLCAA says it bars all actions in state and federal court, which would presumably take care of any state action since it's in a state court. Very important issue. Unfortunately, the petition got filed, and then both New York City and New York State, which are the respondents on it, waived their response briefs. Did not get it got set for conference today. I figured it was getting shot out of the sky. You're not Hannah, you're not seeing that on the list at all?
No.
It's gonna be a relist. All right, here's another case I want you guys all to check out. Check out Cokerham.
Nothing.
Really? All right. What about this case? Zong, ZHONG.
Denied.
Denied. Zong got denied.
Yeah.
That's a little interesting because there's another case kicking around in there. You guys might recall that this is the case involving the military courts. And there was an interesting development on Zong that came in last week where the Solicitor General filed a letter saying that the United States Air Force had, in fact, changed some of the policies that had been point of contention in that Zong case. So I don't know whether it's a temporary fix, a permanent fix, a partial fix. Again, I'm still trying to get my head all the way around the issue. If one of you guys is, any of our viewers out there, we got almost 500 of you tuning in live right now. Thank you very much. If any of you former JAG officers understand that, I would love to talk to somebody who's got a little more knowledge on that to understand the importance of that issue. So, okay, well, guys, we're going to do a few more things. Now, we used to call it the morning scramble. But then things got, so messed up that we then called it the morning cocktail. But yeah, right here, it was called the morning cocktail. But this is getting to the point, we're down to the final. So this one's going to be called Smoking a Pancake. Hannah, you know anything about this? You ever watch the Austin Powers movies, Hannah? I don't know if that's really up your bailiwick there, but all right. Well, there's a Smoking a Pancake. Now that's next week. The week after, we will be cigar and a waffle. The week after, we will be piping a crepe. And then if it really gets to the last conference, we are actually going to go all the way to bong and a blimp. That's how bad it's going to get. These cases, if you guys could just take a peek for a couple of them, we already did the Cokerham case. These are all cases that I believe are getting chopped today. Story, Yanez, Jackson, Hensley, and then Cokerham. What's interesting, obviously, with the last case is the parties are in inverse order, which means the United States government has lost that case. Those are all
Story survived.
Okay.
Yeah, denied.
Denied.
Jackson and Hensley also denied.
Jackson was denied. Okay.
Story not denied, you said?
Hensley is denied as well.
Okay.
So a mix of denials and interesting.
Yeah. Okay. All 922 G1 challenges.
Mm-hmm.
So there we go. All right.
Oh, it looks like SCOTUS requested a response in Story.
Oh, they requested a response in the Story case.
Mm-hmm. Which we learned means nothing, but
it means absolutely nothing, Anna. It means absolutely nothing. Okay. Let me ask both of you guys this. I believe that the court usually publishes its opinions on Thursdays. Is that right?
Mm-hmm. That's what they've been doing.
And it's typically 3 to 4 opinions per Thursday. Is that right?
Right.
That's what they've been doing, although late in the term, they'll sometimes add days last minute. So like last year, for example, they might have a Thursday scheduled, but then on Tuesday say, hey, we're also going to release opinions on Friday this week. You know, they'll as it gets later in the term, traditionally they'll add more opinion days on each week.
Okay.
But,
All
yeah.
right.
I mean,
So
they're gonna have to, right? Or
what's that?
they're going to have to at 3 to 4 rulings per Thursday. They still have over 20 left
I
to
mean,
go.
I guess they could
Yeah.
do 10 rulings on a random Thursday, but they tend to not do that. They tend
Yeah.
to do like them in batches. Also, this year they seem to be going with themes a bit more. Like last week was like a bunch of FTC or similar cases. The week before that was like these criminal cases. Like they're so that's why I'm starting to feel like, you know, the reason we haven't gotten Wolford yet, because I thought Wolford would have been out in May because it's not a hard case. I'm wondering if they're gonna release them together and they're probably gonna reference each other. You know, Wolford might reference Hamani or vice versa. So even if Wolford's done, it might be awaiting Hamani before, so they can release them both at once, which I hate because I want to cover these each. You know, so it'd be nice to have them on different days.
Yeah. To have them kind of released on separate dates would allow us to do a better analysis. As for those of you who've been living under a rock and haven't been following this, as you know, we are awaiting 2 Supreme Court rulings related to Second Amendment issues. One's Wolford v. Lopez, an appeal out of Hawaii. The other one's United States versus Hamani, a challenge to 922G3, the prohibition on cannabis users possessing firearms. So, yeah, as I calculated, they have 23 opinions still left to publish before the term is out. And we're down to about 3 weeks. So,
By the way, Wolford got a supplemental order today. The petitioners want to file a supplemental brief.
Oh, he already filed the supplemental brief.
Yeah.
Yeah.
But isn't that late in the game? So either that, I mean, does that?
No, it's just I don't think it'll matter much. Alan did a brief on one of the I forget what the brief was about. He did a supplemental brief on some circuit case that it was the Second Circuit, the Christian v. James, where they again struck down the vampire rule. So he did a quick supplemental brief on that, and they just approved it. I don't think that case is gonna matter though. It's just the same analysis as before that every other circuit has done except the Ninth Circuit.
So we don't read any indicator into that. They've probably already written the opinion.
They're just approving it as as a matter of form. I don't think it means anything.
there is another sensitive place case right now before the United States Supreme Court. It's the matter of Moore v. Kipke. It comes out of Maryland. It's the Fourth Circuit.
Did that go to conference today?
No, it did not.
Okay.
But here's the interesting thing. It's actually there are cross petitions to the United States Supreme Court. Both Moore and Kipke are petitioning the United States Supreme Court. The Fourth Circuit kind of split the baby. Both sides are happy. They're bringing it up to the United States Supreme Court. At issue, one of the issues that's being challenged is Maryland's ban on carrying in public places, private property held open to public as well. Probably has GVR written all over it, but that is another case that's kicking around. Another case I just recently, I think this is a case that I want to start tracking. This is the matter of Corbett v. Hochul. Can someone take a look and see if that case, I'm not even sure if it was on conference today. Just search out.
It's not on the list.
Okay. All right. Interesting issue. Whether Bruin footnote 9 creates a presumption of constitutionality for shall issue licensing regime firearms training mandate that relieves the government of its burden to justify that requirement under Bruin's historical tradition test. This Bruin footnote 9ing, which has been happening ad nauseum, and now you see the Department of Justice using it to justify the existence of the NFA. At some point, the court is going to need to step in and start limiting this. This Bruin footnote 9, which was designed to be a shield, has turned into one of the biggest swords that's being wielded by the civilian disarmament crowd.
I don't think the Supreme Court wants to come near that with a 10-foot pole.
You don't think so?
I think they like leaving it up in the air, undefined, and they would rather play whack-a-mole with the issues that it raises.
Yeah.
And that's going to be very little of that.
Mm-hmm.
I don't think they have to define it.
I mean,
I agree with that. That's the kind of question that these days the Supreme Court doesn't grant. I mean,
granting a complete Supreme Court review to take a look at the application of a footnote from a case 3 years ago is mildly obscure. I recognize that.
I mean, the circuits are treating it not as a footnote, but as like the main holding of the case. So,
all right, but Corbett still survives for today. Is that right?
It does.
Yeah.
Okay. All right. Well,
I'm wondering if we're angling towards a big GVR right now.
One of my colleagues just messaged that Corbett is scheduled for conference this week. So
Oh, so
okay,
it didn't
it's
go
coming
to
up
conference
this right.
yet.
All right.
Okay.
Who was your colleague that did that?
that's Cole.
Well,
Cole
Cole,
is
thank
my
you very
right-hand
much,
man.
Cole. Cole, thanks for tuning in too, brother. Appreciate that. Cole's been doing a lot of nice work for you guys
He
in
really
the
has.
comments to the ATF rules.
Hey, Cole, don't correct Bill on air, okay?
That's cool. That's cool. Hey, I'm human. I'm human. Why do you think I never do a podcast with Mrs. Gunlaw? Because that's all it would be with power of corrections, you know?
I don't need corrections because I've never been wrong about anything. So. Yeah, I
Okay.
wish.
Well, Kostas, how many years you been married? Because after a while, you begin to realize you're
8 years.
8 years. All right. I got 24 coming up this year. So, hey, welcome new petitions, guys. We haven't talked about new petitions, and I'll tell you why. I went back and took a look at every petition that was filed starting April 1st. Okay, just to see what's going on as it relates to Second Amendment, not every petition, every Second Amendment petition. Okay, here we go. 18 new ones. 16 of them are 922 G1 challenges. Okay, one of them is a 922 G4 challenge about a person who was involuntarily mentally committed. Good luck getting that one accepted.
Yeah.
And then the last case is that Moore v. Kipke, that Maryland sensitive place case. So the 922 G1 cases, the challenges keep coming, and yet this Supreme Court has shown an absolute unwillingness to even sniff at those things. So what do you guys think about all those 922 G1 challenges? Anna, what do you...
Well, historically, and I don't mean just like this year and last year, but historically, the Supreme Court has not wanted to come anywhere close to the question of who is allowed. So it was actually a really big thing when they took Hamani.
Yeah.
A little out of character, frankly, which made me wonder what's going on with that. But I don't think the fact that they took Hamani should be read as breaking the pattern. The only reason they gave us Rahimi was to fix what they saw as a grievous error on the part of the Fifth Circuit that was going to let dangerous people, in their view, be armed. So they kept the federal prohibitor in place.
Well, let us remember who was bringing Rahimi to the United States Supreme Court, too, because it wasn't Rahimi.
Right.
Right? It was the United States that brought it there.
Right. Well, that's what I'm saying. The Fifth Circuit basically struck down that particular federal prohibitor on, in my view, correct grounds. That the due process side wasn't there sufficient to justify the prohibitor. And Roberts gave us a Chief Justice special and said basically, well, no, you can disarm dangerous people. Didn't touch how do we determine they're dangerous, and then left it alone. So basically, they kept the status quo in place.
Right.
And then after that, they've been unwilling to come at the question of nonviolent felons. I think the pattern continues.
Kostas, let me ask you this. There's been like 100 of these cases coming on just this term. And I did a video a couple months ago, and I wasn't really critical of the Supreme Court as a whole, but I was critical of the case management at the Supreme Court. And what baffles me is why they didn't at least hang on to a few of these 922 G1s, maybe 4 or 5 to spread them back to about 4 or 5 other circuits, wait for Hamani and Wolford to come back down. Maybe Hamani has some instructions on it, and then GVR it back, because if the reason the court is not taking these cases, one of the reasons is for them to percolate. It would have seemed like sending about a half dozen of these back to various circuit courts might have allowed for some more percolation and more case law to develop out of that. What do you think?
Man, it's so hard to read stuff like that. I almost feel like if we're assuming there's more method to it than there actually is. And sometimes you'll have cases that they'll keep one but deny another, even though they're pretty similar. And I'm wondering if maybe just it's different clerks doing different things. Who knows? I would love that. That's one of those things where I wish I could get some of the justices or even just their clerks to answer a few questions about their processes, not reveal anything confidential, but just like, how does this work? What does it mean when you put the 18 to the young adult cases in the freezer, but you keep relisting Duncan? Why isn't Duncan and Viramontes and Grant, also in the freezer until you decide, stuff like that. I'd love to have answers to, because I don't understand why they do some of this stuff.
Well, if there's a retired Supreme Court clerk out there with a lot of time to kill and you want to hop on the channel, you want to come on a Behind Enemy Lines one night and sit down and talk to me and Kostas. We've got a lot of questions we'd like that. I would specifically like to ask, like, listen, when you guys weren't ready to deal with Duncan in January, why didn't you just relist it like in April?
Yeah. Or not even relisted. The young adult cases aren't relisted. They're just.
That's right.
They've just fallen off the orders list, and who knows what since November.
Yeah, so these are the cases that Kostas is talking about. He's absolutely right. There's a bunch of 18 to 20-year-old cases, the young adult cases, all of those listed on the right. All of those cases conference like December or January, and they have not been heard from since. And then we got 3 cannabis cases also that had conference that have been just kind of put on ice, obviously waiting for the rulings of Hamani to come down. It would just seem that it would be better case management. I don't know. Maybe efficiency is not a big deal over there.
I do think we can probably go to the wall on that one. I don't think they care at all about efficiency. I don't know what they do care about, but I don't think it's efficiency.
Yeah. Kostas, let me ask you this question. Do you spend a lot of time actually in California courtrooms?
I used to. These days, not as much because I don't do state law anymore. But yeah, at my old job, a lot of our cases, non-gun cases, were in state courts. Yeah.
Are California state courts as inefficient as I imagine they are?
They're worse than federal courts. Yeah. So when we file, for example, when a new case is filed, a lot of times a common step will be what it's called a demur in California. It's a motion to dismiss federally, and those demur hearings will be set 9 months out, commonly. Yeah. That's what happened in the tax case. So the tax case, we're hoping to get a tentative ruling today. It's been delayed twice. But California's demur got filed it's over 6 months ago, I think. Wow. So it's been a while, and that's relatively quick. So
I bring that up because I don't do nearly as many court dates as I used to. I used to do 60, 70 a month. Okay. I mean, it was go, 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 go. So I've become a little bit more in tune with what the court's going on. What I'm seeing up here in the Washington area, because we went to Zoom court during the pandemic and never got rid of it. So we got a lot of hearings on Zoom, and we've gone paperless. The truth of the matter is the workload at the court system has gone down in a good way, but that also jeopardizes jobs. So what you are seeing now is judges setting just these ridiculous, mundane hearings. I think I've been complaining to Hannah on the phone a couple of times, like, I got to go do a hearing now that it shouldn't even be happening, right? Literally. And I have had, I would say out of my last dozen court appearances, like half of them were like, I can't even believe you set a hearing for this. And then you walk in and the judge is like, yeah, I wanted to talk about this. Like,
Wait,
and we talk about it and then it's gone. And then we're gone. I mean, there's no motion, there's no order, there's no ruling, there's no anything. It's like we walk in for a babysitting appointment. It's terrible.
Correction. I guess FPC just posted Cockerham was denied. Did I misspell it when I was searching for it? My bad, guys.
Either that or I misspelled.
Oh, yeah, there it is. Cockerham. It was denied. I think I spelled it COK instead of COCK. Okay.
It may be misspelled on one of my slides now that you say that. Okay, well, this is
shout out to FPC. Thanks, guys, for that post.
Yeah, well, and shout out to FPC for they're doing a argument on the 1 in 30 and this
a local version,
thing down in LA and Inglewood.
Yeah,
good argument that they made on that one. So, well, there's an interesting thing circling back on 922 G1, because we have seen this court absolutely positively have no interest in taking any of these cases, no matter where they come from, no matter who prevailed. And this is a case where Cockerham had actually prevailed at that one. So,
yep, and they denied the federal government, which is interesting. They didn't even hold it for Hamani. That's interesting.
What I mean? There's something weird going on with these 922 G1 cases.
That's true.
I don't know what it is. All right. Let's see. What do we got? Okay. Just to give everyone an update, we were talking about this a little bit earlier. For those of you joining us late, thank you very much. Appreciate having all you here. We got a big nothing burger again today. We're going to be back again on Monday. The United States Supreme Court does have some big cases remaining. Of course, obviously, we're still waiting for these two cases that are most relevant to the stuff that we discuss around here. But let's remember, and this one will be very relevant to Kostas. Kostas, how's the election? How's the ballot counting going down there in California right now?
They're printing enough out to beat Pratt right now.
You have been
election fraud joke. No,
I have been very interested in getting your take and following you on X about this. And I don't want to get too much into election conspiracies and things like that. But Watson versus RNC is a case that's already been argued before the United States Supreme Court. We are waiting for a ruling. This determines how many days after an election, if any, can you count ballots?
Not can you count? It's you can count. It's I think how many days after can you count ballots received that were cast at or that were received after election day?
Yeah. So I understand that Mr. Pratt has now suddenly slipped into third place in the Los Angeles city election.
So the candidate who was in third place on election night is now surging. And she seemingly conceded, and now she's beating not just Pratt but also the mayor Karen, the incumbent in the late returns. So she's surged to second place. Look, there is an explanation for why that happens, which is that younger voters vote later. They tend to be more liberal. However, it is very convenient, and it's just frustrating that they've, as I've posted about. You don't need fraud for this to be wrong because it's wrong because it doesn't even avoid the appearance of impropriety. It erodes confidence in elections. They shouldn't count this way. You shouldn't count ballots that you receive after election day, just as a matter of principle. So yeah, it's deeply frustrating. It's not surprising that LA is going to continue voting for stupid people. I mean, they've been doing that for 40 years. Why stop now? Right. But it is still disappointing because it looked like we'd at least have a candidate in the general election. I say I can't actually vote in LA mayoral races because I'm county, not city.
You're outside city limits.
Yeah, I'm outside the city limits, but still it affects me, so.
Of course it does.
Yeah.
Just like our incompetent mayor in Seattle.
Mm-hmm.
I don't live inside the city limits of Seattle. You could put a gun to my head. I still wouldn't move inside the city limits of Seattle. But it is right across the lake from me here. And what happens over there does affect here as well.
Mm-hmm.
Hannah, let me ask you this question while we're on elections real quick. I believe, and I want to, because you very astute political mind. I believe one of the biggest reasons we have massive polarization in this country when it comes to politics is, number one, we do have some inflammatory politicians on both sides. But in addition to that, there's a general lack of faith in our election integrity on the level. What do you think?
There is, and that's really, really troubling to see. The thing is, people are people. Human nature is human nature. It's that way on both sides of the political aisle. Yeah. Where there have been people jockeying for power, there will always be fraud. It is always there. But the more you watch government up close, the more you see the absolute organization that would absolutely need to be in place in order for all of these conspiracies to be true. I'm not saying fraud doesn't happen, but I am saying you've got way too much faith in the competence of government to pull off what you think they are pulling off. Some of the fraud is happening. But the reason conservative principles tend to lose is because we don't organize properly. Again, just organize, outnumber them. And the other nice thing about organization is that it tends to shine a spotlight on what's happening. And transparency is always the precursor to accountability. So do something about the fraud. I think the reason fraud is such a convenient excuse is because it enables the armchair quarterbacks to stay on their armchairs.
Yeah.
If there was something you could do about it, then the question would be, what happened to you? But if it's out of our hands anyway, then why bother to get up and do something about it? I think that's really the heart of what's happening. And it's troubling to see, because the more you actually believe there's nothing you can do, then it's a vicious cycle. The less you will do, and then the more we will lose. Not because there's fraud, but because we're not doing anything about it. So it's a troubling trend. It's very troubling.
Wise words. I appreciate that. Here's some other cases that we're waiting for. This is one that I think is going to garner a lot of attention out of the media. This is Trump v. Barbara. I'm not sure how it's pronounced, but this is the birthright citizenship case, the application of the 14th Amendment. There's a lot of different ways you can slice that pie. I look at it as, can a president change the application of a constitutional amendment through executive order? I believe the answer to be no. We also have Trump v. Slaughter. This deals with the termination of the chair of the FTC and whether or not that exceeded the president's authority. It will be a very important case as the presidential authority. Two other cases, especially if you live behind enemy lines like Kostas and I do. Hannah, I don't think you have to worry about this as much in South Carolina. Little B. Hickox and West Virginia versus BPJ. These are bans at the high school level on trans athletes competing in the opposite sex sport. So basically, it's a ban on boys competing in girls' sports. One of the two parties tried everything in the world to moot this case, even after the Supreme Court heard it. The Supreme Court was having nothing to do with it. So those are going to be really, really interesting cases. And then this is one I probably will end up doing a video on when it comes out, because I think it's going to be mildly fascinating. It's a Fourth Amendment case, Chattree versus United States. That actually deals with geofence warrants, which is actually a pretty cool topic. So either of you been following any of the Carmelo Anthony trial in Texas?
No, I know
you were
that.
tweeting about it though.
What's that, Hannah?
I saw that you've been covering that. I have not been following it.
All right. What about you, Kostas?
I mean, I followed it when it first happened, but I haven't followed the case developments really, no.
Well, I don't know who the judge is down there, but that judge knows how to step on a gas pedal, because that trial started on Thursday. They went through Saturday, and I think they've gotten through 21 witnesses already.
Wow.
Yeah. Yeah. I mean, when I heard that, I was like, 21 witnesses? That takes a month to get through 21 witnesses. And I've been reluctant to cover the case on a play-by-play basis, because the problem is there's no live cameras, there's no live audio, and there's no live transcripts coming out of the courtroom. Judge's orders. That's fine. Judge can run the courtroom however he wants. So the problem is you're relying on reporters to give you summaries of what was said in the courtroom, and the nuance of what was said, how it was said, the body language that comes with it, the tone, everything like that is kind of important. I think the defense team in the Anthony case has an uphill battle, without even getting into the facts. The law, there's two laws here. One, of course, is the proportionality of the force used. So even if the kid was allowed to use some force in defense of himself, I don't know if he could have risen to the level of lethal force. The other thing is Texas has some pretty harsh instructions as it relates to what they call provocation, or what most states call the first aggressor standard. And there's going to be good evidence that Mr. Anthony may have been the initial aggressor. And if you're the initial aggressor, you preclude yourself from raising self-defense whenever. So interesting case. I think the case is going to conclude this week, to be honest with you. I think that they'll probably, I think the state is rested. So defense starts up today. I can't see the defense putting on more than a 2-day case. I've seen the list of their witnesses. Not sure what's going to really drag on. So the jury could have this case by Wednesday or Thursday of this week. And that's going to be really interesting. And then the reaction to the verdict, of course, will be equally interesting.
How do you think that was going to go?
Well, I don't want to get into prognostication. I just say this much. If I was on the Carmelo Anthony defense team, we would have our work cut out for us.
Yeah.
Okay. And I'm not trying to, there's so much other stuff spinning around on this case. And when race gets injected into the criminal justice system, it screws it all up. So I'm just going to follow the evidence as it goes on. Obviously, the case looks very strong right now because the prosecutor just rested. The prosecutor's case always looks strongest right after the prosecutor has rested. Okay. So, where that goes. I'm interested to see what the defense is over the next couple of days, what they're going to try to set up. And I'll probably have a clearer picture. But right now, if I were a betting man, which I'm not, I think the kid's in trouble. I think he's in big trouble.
Well, I mean, I don't think this case would even be interesting if it wasn't for the tribal racial politics of it. Like, it's a pretty, if the facts are even generally what the witnesses and everyone who was there says, then it's a pretty open and shut murder case. I mean, maybe he didn't, what's it called? Maybe it wasn't premeditated or anything, but it's a murder case. He got shoved and he stabbed the guy. That's not self-defense anywhere.
No.
Right. There is enough evidence that has come out that one could make an argument that it was premeditated if that evidence is believed.
That's why I haven't followed it closely enough.
The
My bad.
defense did not do a lot of cross-examination on all the high school kids who were eyewitnesses to the, ones that were standing right there when it went down. Their testimony was pretty damaging to the Anthony defense. And I also think that having been a trial lawyer for many years, sometimes cross-examining a young kid and beating them up doesn't really get you a lot of brownie points with the jury. So sometimes you just gotta let a few things slide. So I'm going to be interested to see what the defense theory of the case is. But yeah, I think Kostas brings up a good point. This tribal racial component to it is disturbing. I think that if we reverse the races of the victim and the perpetrator, I think mainstream media might be covering it quite differently as well.
Oh yeah.
And I could have sworn Lady Justice was blind. Is that how she looked when you went to law school too, Kostas?
Yeah, that's kind of like the whole justice delayed is justice denied thing. Nobody actually believes that.
It's like a perpetual motion machine. In theory, it works really well.
Nice fairy tale they tell people. It's not true at all. I mean, it is true that to be clear, justice delayed is justice denied. The lie is the implication that the courts care about that. They don't.
There you go. There you go. Hannah, we're going to wrap it up here pretty soon, but tell us a little bit about what NAGR has on slate for this week.
Kind of big week for us this week. The South Carolina primaries tomorrow, and we're usually pretty good about wrapping it up in one day. So
you guys going to get all your votes counted in a day? That's awesome.
I think we might.
How American of you.
And since it's a deep red state, the primary is where the real contest is. So tonight we will know who our next governor is going to be and our next attorney general.
Who's the front runner for your next governor?
That depends on what pollster you ask and how
credible you got a tight race out there.
It's a tight race. It's tight for both attorney general and governor. I will say I think attorney general is the more important race. South Carolina's constitution defangs their governors and puts most of the control in the legislature. Balance of power out here is kind of a bit of a misnomer. Attorney general, though, there's a lot at stake with that one. So going to be very, very interesting.
All right. Interested to hear. Kostas, what does Second Amendment Foundation have coming up this week?
Well, the main thing I'm looking for, as I alluded to earlier, is around 1 o'clock today, 2 o'clock. We should get a tentative ruling in the excise tax case, the state court one. This is California's demur motion to dismiss, as most people would know it. And this is in state court, so it's hard to be optimistic. That said, the judge has put off this ruling twice already, so I hope he's at least giving it serious consideration. It might just get delayed again. However, this time, the last 2 times he delayed it for 2 weeks. He said, and the hearing is continued 2 weeks. This time he only delayed it for like 8 or 9 days. So I'm hoping that means he feels like he's just about there for a ruling, but we'll have to see. And so a tentative ruling, although it's called a tentative, it's in California, state courts have a practice where they'll publish a tentative ruling the day before oral argument, and then you basically go there and the judge has told you what he thinks, and you try and convince him otherwise. So 9 times out of 10, the tentative ruling is the final ruling, maybe with some minor adjustments. I've flipped a tentative once, which I'm very proud of, not in a gun case though. Usually in a case like this, it's hard to flip a judge because it's an ideological case more than you miss some facts or technicalities. So usually what they'll do is they'll hear from the other side, and they might adjust their wording a bit to account for arguments, but the core holding doesn't change. That said, we'll have to see. And a lot of times there is no argument because you can submit on the tentative. So sometimes both sides will agree, the loser will see like, yeah, I'm not winning this, whatever. And they'll just submit on the tentative, and then the tentative becomes final. So we'll have to see what happens if we actually get it today. If there's not another delay, then I'll do a thread on it to cover what it is the judge ruled on the tentative. So, yeah.
This is on the 11% tax on.
Yes, yeah, it's the first court ruling we're getting in an excise tax case, state or federal. I think this is the first ever. Yeah,
I think you're right.
At least on Second Amendment grounds. There's obviously There's been NFA cases, but those are mostly there's been some Second Amendment arguments in the NFA cases, but it's mostly been taxing power issues. Yeah.
We have one case in the Washington State Supreme Court that has already addressed that, but you don't need to look it up. You can imagine how that one went.
Yeah.
With Tacoma's tax. So, and then Kostas, you and I are back again together at 5:00 West Coast tonight for Behind Enemy Lines, Volume 9.
Yeah.
And we got Cam Edwards on the show, and we're really excited to talk to Cam. Well, first of all, Cam's a hell of a good guy, and number two, a very good 2A journalist. Been doing it forever. He was actually like the original 2A content creator. If you go back and you look at things, it's like Cam was creating 2A content before anybody else was. But he's a Virginia resident, and as you know, we got a lot of Commonwealth attorneys out there in Virginia, and a lot of sheriffs saying, "No, we're not going to enforce these bans." And so I'm interested to find out from Cam what the lay of the land looks like out there and what's really going to happen come July 1st. So
It'll be interesting.
All right. For those of you who are joining us late, thanks for being here all the same. A big fat nothing burger is on the menu again today. So our 5 platform ban cases that we've been following, which is, of course, Duncan, Gators, Viramontes, NAGR, and Grant, have all been set over presumably to next week. So we're likely going to be back on, I guess it would be Monday, June, what would that be? June 15th, a week from today. We'll be back again. This will be down to 3 conferences left. So this Friday, after this Friday, there will only be 2 conferences left for the term. Is it possible that these cases run all the way out to the end and then we start back in the fall with our new version of WGL AM? I don't know. We'll see. Also, Washington Gun Law will be out in Denver, Colorado this weekend for the Rocky Mountain Gun Owners Association's big fundraising banquet. They were kind enough to invite Washington Gun Law to come out there and give a pitch for RMGO. I'm on the program with Miss Lauren Boebert. I'm excited about that. I can't wait to talk to her about her Freedom from Tax Act, which is an interesting piece of legislation that not sure how it's going to get passed, but it's an interesting piece of legislation. So. All right. Well, both of you, thank you very much. Kostas, thanks for getting up early in the morning. I know it's a little easier for Hannah. Hannah's an early riser too. But she's out there. You're not an early riser, really?
No, I hate mornings so much.
Really? I'm a big morning person, and I'm
always been a night owl.
I'm the only one in my family like that. So, like in the summer times, on weekends.
You're a popular guy, aren't you?
Like 4 hours before I even hear a peep out of anybody but my dog. So, Kostas, I will see you this evening. For those of you who want to tune in, especially if you're out there in Virginia, check out the show tonight. Kostas and I will be doing about 30 minutes on a bunch of other stuff related to Second Amendment issues, litigation issues, legislative issues going around the country. And then we'll have Cam on for about 30 minutes. And we're just going to be talking everything Virginia. Let's get it straight from the guy who's got boots on the ground right there. So everyone have a great work week. Hannah and Kostas, thanks so much for being here. Any last words from either of you before we send everyone off for the day?
Perseverance is the watchword for the rest of the month.
That's all we got, isn't it?
We're in the end game now, as to quote Dr. Strange.
All right, guys. Thanks so much for being here. All of you have a great work week. Stay safe.